Hi, and welcome back to Stop Being Sold. My name is Michelle, and I'm here with Brian. And in this video, we're breaking down the top 5 estate planning tools that you can use to protect yourself, your assets, and your family in the event that you are incapacitated or die. But there's a lot more to estate planning than a will or an irrevocable trust, and you don't need to die in order for them to take effect. So, Brian, let's get to it, dive in, and let's start with the first estate planning tool, which is the power of attorney or the POA.
Yes, let's start with that one. A power of attorney legally grants someone else the authority to make decisions on your behalf when you can't. By appointing a trustee individual as your agent, you ensure that your affairs are properly managed if you're unable to do so. The agent can have extensive or limited authority to make legal decisions about the principal's property, your finances, your health care. Everything depends on what's inside the terms of the POA.
Also, know that you can set up a power of attorney in different ways, not just for different things. For
Right.
example, you can set up a POA that only happens when you're no longer capable of handling your affairs for yourself, or one that goes into effect immediately so your agent can act for you in your absence.
Right.
And you can also set up a power of attorney for your kids to grant someone else the right to take care of your children, correct?
Yeah, that's right. This is a separate type of power of attorney.
Okay.
Basically, it's a temporary delegation of parental authority that is often used when parents cannot take care of their children for like an extended period of time, usually up to 6 months or a year.
Okay.
This isn't a bad thing to look into if you want to prepare for the unlikely event that you're unable to make decisions for your children.
Right.
But these are also used if you're leaving your kids in someone's care for an extended period, or you're in the military, or you're even deployed.
Got it. Okay. Good to know. So before we move on to the next tool, I'll just say this real quick. I have a power of attorney for a family member, and I have one designated on my behalf. And I can say from experience, it's really important to pick someone who will take this role very
Definitely.
seriously and follow your wishes.
Yeah, I agree on that one 100%. It's a matter of trust, and you need to appoint someone who will honor your wishes.
Absolutely. And that's key. Someone you can really, really trust. All right, so let's move on to the next tool, which is a living will, which I personally think is one of the most important legal documents you can have in place. You can never be too young to set this up. I've had one since I was 22.
Yeah, very important document. Living will's a document that spells out medical treatments you would and would not want to be used to keep you alive in case you become incapacitated and unable to communicate your personal preferences. It also lists your preferences for other medical decisions, such as pain management or organ donation. This is a powerful tool that provides guidance for healthcare professionals, ensuring your treatment decisions align with your personal values and your beliefs.
Yeah, and setting this up really requires you to get clear on what you want, and then, of course, find that person who you can trust to adhere to your wishes, because I've been there. I've seen it happen before. And if your wishes are to pull that feeding tube, God forbid, you
Right?
need someone who is willing to do it and will stand up to other family members, because when that moment comes, it's not always pretty. So,
No, it's not.
all right, I have an idea. Let's lighten the mood. let's lighten the mood just a little
Yeah,
bit,
please.
and let's talk about the last will and testament.
Oh, that's a good one. That's an estate planning tool that allows you to outline how your assets will be distributed upon your passing. Through a will, you can specify who will receive your belongings and even appoint guardians for any minor children that you may have.
Okay.
It serves as a clear roadmap for the equitable division of your estate. If you don't have one in place, it can be a pretty ugly situation when you pass, especially if you have minor children. Think about that. Yeah, let's use an example. Let's say you got a couple in their 40s with two kids. Let's say both parents pass away without a last will and testament.
Okay.
The distribution of their assets and the guardianship of their children will be determined by the laws of intestacy, depending on where they live. Low issue there. So think about this. The couple's assets will then be divided equally between the children, and the court will decide on the guardianship based on the best interest of the children.
Yeah, no.
No. Do you want the courts deciding what's best for your kids?
Probably not.
No. Also, note here, having a will does not mean you bypass probate. Some people think that. Most wills still will go through probate depending on the judge and the court of the state.
Interesting. Okay. It's morbid to think about, but it's really important because I don't know anyone who would want a court deciding what to do with their kids.
No, no.
Just me. All right. So, different from the last will and testament is the living trust. Let's move on to that and talk about what it is and how it's different.
Yeah, bypassing probate is one of the biggest differences between trust and wills.
Okay.
Revocable living trust offer a flexible and efficient way to manage your assets during your lifetime and ensure the seamless transfer after your passing. And when you create a trust, you can place your assets into a separate legal entity that you control. This tool allows you to bypass, the often lengthy probate process. It minimizes your estate taxes and maintains privacy for your beneficiaries. That's one thing that a will does not do.
So, real quick, in the will, it opens it up in the court so everyone knows who's in it.
Everyone can see it. You can look it up just by typing in someone's name on Google on that court document site. So,
okay, all right, got it.
Also, when you talk about trust, there's also irrevocable trust.
Sure.
Okay, an irrevocable trust is a type of trust typically created for asset protection and reducing federal estate taxes.
Okay.
They're designed for the creator of the trust, which is the grantor. They can designate assets of their choosing to transfer over to a recipient, the beneficiary, while they're still alive. Let's talk about this one for just 1 second. I can use an example. I had a client set up one of these before I met them. And their goal was to try to she didn't like it after she set it up. Well, the problem was she had already gave away all the assets to the trust.
Oh.
It's irrevocable.
Revocable, right, of course.
She has had, basically had husband had passed away a few years prior, and this was all done ahead of time. And now she's remarried, and none of them assets are available to her.
Right. And I just, neither Brian or myself can offer financial advice, and we are definitely not attorneys. And this is when you need to bring in an estate planning attorney and understand every single thing about what you're setting up. And if you don't sign it.
Well, that's it. Yeah. I'm glad you mentioned that. Yeah. We're definitely not estate planning attorneys here, but we deal with this stuff on a daily basis. So we understand it, and just wanted to provide the information to you so you get a good sense of what's coming.
Absolutely. Okay. So let's move on to the last tool of estate planning, which is assigning a beneficiary to your assets, like a 401k or an IRA. Break this down for us.
This is the easiest thing that you can do to protect your assets, Michelle, and that's assigning a beneficiary to all your assets. You'd be amazed, though, how many people just don't do this. One of the very first things I look at when I sit down with a consumer today is, who's your beneficiaries? How are they set up? Do you have beneficiaries on every single account? So, folks, well, you may think I don't need a designated beneficiary because the money automatically goes to my spouse, or you think I don't mind if it goes to my estate because whoever inherits my estate will receive it. It's not quite that simple.
Nope.
And if you don't designate a beneficiary, your family members may need to go through your probate court and deal with all the legal ramifications and the administrative headaches that go along with it.
Yeah.
If you don't name a beneficiary on your 401k, the state laws may even dictate where the assets actually go to.
I did not know that. So wait a second. If this is specifically on a 401k, state laws can dictate where those assets go.
Yeah, and plan providers sometimes will name a spouse automatically. And even if the spouse isn't the one you want to receive this, they would have to sign off on a spousal waiver. So you got to know this stuff. So when someone passes away, a majority of their assets are frozen until a will is located and then validated in court.
Okay.
With any debt still owed are then paid before the assets are released. And this is known as the probate process. And if you have a living beneficiary listed on your retirement plan, the assets in those accounts will not be subject to probate.
Woo, doggy. Another misconception as well as we're talking about this. I'm sorry, I'm still stuck on the 401k can be, wow. All right. Let me get my thoughts together here. Another misconception on this is that if you don't name a beneficiary on your retirement plan, like it will default to who's listed in your will. Correct. Yeah. This is a thing. And in the case of retirement funds, not naming that beneficiary will leave the determination up to the plan document or default terms of the account, correct?
True,
It's an
true.
absolute headache and a nightmare for those you've left behind.
Yeah, it is. And like I said earlier, Michelle, this is the easiest thing to fix.
Sure.
For retirement plans, pick up the phone, call your plan provider, and find out what form you need to sign.
Sure.
You'll want to add beneficiaries to any asset allows beneficiaries, such as annuities, bank accounts, investment accounts, whatever it is. Just get it done. It's really simple to do.
Yeah, it is. It's literally signing a piece of paper. So make those calls if you don't have it.
Right? Exactly.
All right. So here's the thing. If you like the content of this video, a bit morbid, but hit that like button. Don't forget to subscribe. And these really, I mean, this is morbid, but this is really important because some of those things you don't want a court coming up with who's taking guardianship of your kids. And you definitely don't want your 401k plan provider deciding who your real spouse is.
Or to follow up on that, on the 401k, let's hit one more big point, and I almost forgot about this. How many of you have went through a divorce and still have your ex listed as the beneficiary on your 401k when you first set it up 20 years ago?
Yeah, a lot of people. A lot of people.
Check that stuff, please.
All right. All right. So here's the deal. We're going to drop a video that we did. We're talking about preparing today and planning. This is important. It has nothing to do with estate planning, but it is critical. It is about the 1099 tax rule. 1099K tax rule that may cost you a boatload in time, paperwork, and double taxation if you don't prepare now. So do go check that out. We're going to put that in the description below and also the pinned comment. While you're at it, if you like the content, again, hit that like button. Help us grow this channel. Send this video to anyone you know that needs to hear it. And that's about it. Thanks, Brian, and thanks to everyone who watched.
Thanks, everyone. Have a great day.